The title of the paper is Competition Policies vis-a-vis Intellectual Property Rights. The authors are Mr. Pritish Sahu and Ms. Taruna Jaiswal. The present study addresses the nexus between IPR and competition law in general, with a focus on India and more specifically an interface of both these two fields of law with respect to the TRIPS agreement. In the end, the authors argue that the existing Indian Competition Act is not prepared to trade with the relationship between competition policies and IP rights. It remarks on the shortcomings and lack of satisfactory laws, the case laws which makes the problem more complicated, and recommends that the Competition Commission of India must come out with IP rights and competition guidelines in order to tackle with such cases. Coming to the intersection of both fields of law, competition law and intellectual property law, although polar opposites in their treatment of monopolies, share common objectives. Competition law treats intellectual property as no different from any other property, and in that sense, licenses are no different than other contracts for the purposes of competition. There are certain situations peculiar to licensing intellectual property where competition law becomes relevant. The conventional role of competition law has been to encourage effectiveness in the market and thereby avoid market distortion, whereas the role of intellectual property rights has been to encourage inventions and innovations and giving protection to such inventions. When the IP protection is anti-competitive in the market, IP rights given to the inventor is not per se in conflict with the norms of competition law and does not lead to anti-competition or excessively exploitative. It only becomes anti-competitive when the owner of the IP right seeks to extend beyond its scope. It is a known fact that intellectual property rights confer an extent of exclusivity to the right holders, automatically constraining the ownership to the others. On the contrary, competition law seeks to encourage competition and encourages access to the market. Evolution of competition in a marketplace. Competition is directly the result of number of players present in the market. The more number of players is the result of greater number of consumers. Consumer expenditure is directly proportional to per capita income of the consumer. When there is demand, there is supply. The current competitive marketplace is the outcome of an evolution from production of commerce and trade in harmonized natural merchandises to markets for highly varied and synthetically tangible or intangible products. From the chart below, we can see that consumer spending in India increased to 9814.63 billion in Indian rupees in the fourth quarter of 2013 from 8737.14 billion in Indian rupees in the third quarter of 2013. This report was by Ministry of Statistics and Program Implementation. According to 83rd Global Retail Development Index 2012, India was stated the fastest growing retail market. 92% of the sector is unorganized, those that fall under mom and pop stores, and only 8% is organized, those dominated by retailers who have multiple stores. Food and grocery, shaded in purple, comprises of 60%, miscellaneous others 11% shaded in green, apparel 8%, mobile and telecom 6%, food and services 5%, jewelry 4%, consumer electronics 3%, and pharmacy 3%. The overall market is $500 billion in the retail sector. As from the comparative chart below, you can see that India has increased tremendously. Looking at the historical perspective, the issues related to the use of IPRs and competition policy have been overstated by the judicial and administrative doctrines from the starting of the 20th century. The conflict between those two fields of law was primarily in the USA and soon after it came in the European Union. And now it's coming to India. In the stated case, the Burke Photos Inc. vs. Eastman Kodak Co., a US court commented, the mere possession of monopoly power does not ipso facto condemn a market participant. But to avoid the prosecution, the monopolist firm must refrain at all times from conduct directed at smothering competition. Thin line between competition law and intellectual property rights or not so. In Amir Hussain Khan Productions versus the Director General, court examined the concept in India as per to give a clear picture as where the role of intellectual property will start and when the role of competition law, and when there is an intersection between these two fields of law, such sophisticated issues can come up in relation to technological developments. There has been anti-competition claim. In this case, Singhania and Partners LLP vs. Microsoft Corporation Private Limited, an Indian firm, filed a complaint against Microsoft India, charging anti-competitive exercise and the misuse of supremacy in the Indian market in relation to their software, Windows operating system and Windows Office. The decision was made by upholding the CCI ruling. The Competition Appellate Tribunal said that Microsoft did not abuse its dominant stand in relation to its software license. In an order dated 9 October 2012, Microsoft faced numerous cases in different jurisdictions like in US and EU, where it suffered adverse rulings, but this went in favor of Microsoft, which is significant to note. The other case which came up to CCI in relation to practice of anti-competition law was where DTH operators were misusing their dominant position and trying hardware with other technology products in the high technology emerging Indian market. The CCI vindicated the DTH operators, saying that there is no such concept as collective dominance in the Competition Act of India. Coming to our next topic, restraints in the Competition Act 2002. The line drawn between competition law and intellectual property laws has advanced through numerous kinds of controls on competition, although neither has pursued to assert that licensing contracts are by itself anti-competitive. The emphasis of these restraints is usually a licensing contract which could unfavorably influence competition by falsely splitting markets amongst businesses and perhaps hampering their expansion of original stocks and services. More precisely, the sensation of exclusive licensing, demonstrated through numerous autarkic market strategies by companies such as dealing in exclusive, restrictions on licensing comprising provisos of grant-back extensions of intellectual property terms and restrictions of field use design arrangements, in addition to parallel contracts like pooling, mutually acquiring market influence, have fascinated the mind of competition supervision consultants around the globe. Under Section 3 of the Competition Act, the Competition Commission is required to look into agreements which are anti-competitive in nature, and those found to be anti-competitive are declared void. However, Section 3, Subclause 5 of the Competition Act incorporates an exemption for licenses of intellectual property. In Subclause 1, the licenses contains reasonable conditions. In Subclause 2, if the conditions are necessary for the protection of intellectual property rights. What is the reason for such exemption in Section 3 of the Competition Act? This exemption is based on the rationale that intellectual property rights deserve to be cocooned, since a failure to do so would disturb the all-important incentive for innovation, which itself would have knock-on effects in terms of a lack of technological innovation and reflect a lack of quality in goods and services produced. The two very important tests to be applied to a licensing restraint. Whether a license is held by a competition law is to be decided by analyzing it with the help of two tests. The first test is the rule of reason and the second is per se rule test. The plaintiff under the rule of reason analysis has to prove that the challenged practice actually harms competition in the relevant market. The defendant can escape liability if he shows that the same has pro-competitive aspects which would outweigh any harm to competition. Under the per se analysis, the licensing arrangements are treated as per se unlawful without an inquiry into its competitive effects. Section 3, Subclause 4 of the Competition Act echoes the per se rule and declares certain arrangements to be anti-competitive if they cause or are likely to cause an appreciable adverse effect on competition. Coming to the very essential doctrine, the Essential Facilities Doctrine. In this doctrine, it was enunciated to make the essential facility owned by one firm available to their rival firms. This was a duty which was imposed in a firm in a United States Supreme Court judgment in the case of United States vs. Terminal Railroad Association. Also, Section 4 of the Indian Competition Act 2002, which forbids misuse of dominance by enterprises. In the case of Commercial Solvents vs. Commission, the court made an observation that a denial to supply could in some conditions result to an abuse of dominant position. Further in this doctrine, it is stated that where firms own significant inputs that are protected by patent, copyright or trade secrets, thus this doctrine created an impact and resulted in consequences for protection of intellectual property and for competition in markets. The doctrine cannot be invoked merely on rejection of IP licenses applications. There has to be supplementary exceptional circumstances to invoke this doctrine. It is personified in TRIPS, some kind of retort to alarm that safeguarding of IPRs would attract gratuitous abuse of market control. The next topic is TRIPS beneficial for the competition policy? The classification of rights in the TRIPS agreement try to find out the ways to pin down a satisfactory and intrinsic balance with the entity for competition. There are common contemplations in the preamble accompanied by Article 8 subclause 2, letting members to take suitable actions in order to avoid abusive functions. Also, there are a handful of very accurate stipulations involving competition law. They permit fair use and the option of compulsory license on the permitting of patents, that is the conferring of a right by public agencies, and against the wish of a patent holder to make usage of a patent to the degree required to grow a novel product. In exercise, this permits nations to allow limited use of invention attainments for personal and non-commercial works, that is, in development and research work. Article 31 of TRIPS offers for the permit of compulsory licenses under a range of situations, such as the significance of community health, nationwide emergencies, insufficient utilization of the patent in a nation, anti-competitive works by the patent owners, and complete national interest. The correctness will only come from the multilateral framework within the WTO on competition issues, with significance to the regulation of IPRs, which may facilitate to have power over exploitations and basically be in charge of manipulation against less developed countries. Not being successful to restore this fragile boundary of the woodblock may well be an unalterable blunder with grave aftermath. The next topic for the study is the Indian scenario of IPR and competition law. In Raghavan Committee report on competition law, it was stated that all varieties of IP have the capacity to rear competition policy problems. Intellectual property provides exclusive rights to the owner to make a productive and profitable activity, but this does not contain the right to exert restrictive or put monopoly in a market. Furthermore, competition control points at limiting attempts to extend abuse of an intellectual asset beyond the limits provided by IP rights. Thus, there is an intrinsic conflict between competition laws and IP rights. Exceptionally, if competition laws give importance to still markets access and IP rights highlight enticements for active competition. Defined properly, the two governing laws balance each other in hitting a correct stability point between demands for invention, technology transfer, and information propagation. Is the Indian patent law in consonance with the competition policy? According to Section 3(3) of Indian Patents Act 2005, it is proposed to check the bestowing of patents for new usages or somewhat altered forms of known molecules, unless a noteworthy improvement of effectiveness can be established. It is clear from the intention of the legislator that the section of the Indian Patent Act is to avoid any kind of anti-competitive behavior in the market. In the landmark judgment of Supreme Court in Novartis AG vs. Union of India, which opened the gates for competition restricting monopoly therein, the Supreme Court's decision is consistent with the TRIPS and has been arrived at not arbitrarily but by following transparent and internationally accepted legal processes. In the conclusion, I would like to say that implementation of competition laws no longer initiates with the supposition that obstructive usage of IPR rights is essentially anti-competitive. Competition law concerns have also been internalized in intellectual property, which reveals the close links between these two areas of law. Also, IP rights is akin to other types of properties so that proprietorship specifies the same rights and obligations. Second, the survival of IP right does not mean that the proprietor has market power. And thirdly, the licensing of IP may often be essential in order for the proprietor effectively to combine balancing factors of manufacture and therefore may be pro-competitive. The authors in the end would like to say that clashes will happen when intellectual property rights serves to embed market power. A rigid balance thus should be retained and naive methods should be evaded at all costs. Thank you. This presentation was made by Mr. Pratish Sahu and the narrator of the presentation is Ms. Taruna Jaiswal.